May I be permitted to mention one matter? It's an appeal against contempt, my lord, which is running as item number 504 of your lordship's list. My lord, the urgency is that, my lord, the bank, due to this order, bank is precluded from realizing the security. If your lordship, at any convenience, if your lordship can, I'm giving the list.
To mention one word for inclusion, especially traffic, especially traffic.
My lord, I am mentioning this contempt application be kept under heading to be mentioned, my lord. Original direction was my lord justice with my lord sitting with my lord justice Arun Mishra, my lord. Against that contempt filed, but file could not be traced. On last occasion, my lord had directed to give a report. What is the status? But till that, the matter has not been. So that kindly keeps it tomorrow, my lord.
We'll try.
My lord,
You're looking for admission of
Have you reconstructed the
my
file?
lord, that is the order that has to be passed, my lord, by my lord. Tomorrow to be mentioned, my lord.
You're looking for admission of appeal.
All the list. Pass to who?
There he is.
Yes.
Kindly release me on my personal ground. My lord.
You don't want to appear.
Yes.
Mr. So-and-so is present in court. He expresses his unwillingness to represent the appellant. Copy of the Mr. Ahmed, learned counsel, empaneled with High Court Legal Services Committee, shall represent the appellant. Matter shall appear 2 weeks hence. Copy of this order be communicated to the superintendent district a correctional home shall communicate copy of this order to the appellant.
Bahrampur correctional, blood, he says.
Bahrampur correction to the appellant.
ঠিক আছে ঠিক আছে কিন্তু কিছু তো করেন নি আমিও বিপদে তুমিও অবলাজ না কার হাফিজ হাফিজ তোর নাম
Yes, next matter.
2 and 3 appearing for the appellant on High Court Legal Services Committee.
Lord, I am for the appellant in item 5, my lord.
Parties are requested to collect the paper book. Matter will be fixed for hearing in the monthly list of April 2005.
Lord, I have filed a suspension of sentence, my lord. I'm in custody for more than 15 years.
Who are custody for more than 15 years?
My lord,
All
2 and 3, 2 and 3 about 16 years.
So we'll suspend this sentence. Appellants are in custody for more than 15 years. The paper books are ready. There is little possibility of the appeal being heard out in near future. In view of the aforesaid situation and the law declared in Sodan Singh, we are inclined to suspend the sentence. Parties are requested to collect the copy of the paper book and add it to the list in April 2000.
There are two appellants, even that has been tagged, where the conviction is under 411. Sentence 2 years.
They are on bail.
They are on.
Whoever is
Item
15 and 16 years, you have filed application for suspension?
Yes, my lord. Item 5, my lord.
Item 5.
Yes.
You have filed
No,
application?
no, my lord.
Alright, so item 5 we are allowing.
Item 5.
in item number 5 I am appearing on.
Yes.
No, Khali
And
5.
allowed.
5
And 2 of 2024 for Shilpa Manna.
আমাদেরটা তো ফাইল করতে হবে।
Yes, next.
ফাইল করে দাও।
Defect.
6 minute I am for the de facto component. On the last occasion, your lordship have asked for report by the IO, whether they have been apprehended or not.
Defects are minor and may be ignored. Paper books be prepared. Good stuff. Nobody appears for the state. Report with regard to apprehension of the absconding appellant be placed on record. Adjourn 4 weeks.
I'm great.
With paper books be prepared. Yes, next matter.
Lord, sir,
I was directed to be present before the medical board on 10th of February. But I appeared before the medical board. I was examined. But again, I was directed to be present on 17th along with all medical papers.
Yes.
But I appeared before the medical board with all medical papers. But a report may be called for from the SSKM hospital.
Yes, sir. ওইটা আপনাদের কেন? হ্যাঁ, it is different from what. খুলে দাও না। আমি খুলে দাও।
এই কি বলছেন? আচ্ছা কি বলছেন? রিপোর্ট দিস।
We have perused medical report. Medical report shows patient is suffering from এই এখান থেকে যা যা আছে দিয়ে দাও chronic disease stage 4 with moderate aortic stenosis and moderate aortic regurgitation. ECG shows left LVH. Board opined patient may require hemodialysis in near future and surgical aortic valve replacement.
It also matters how your
Opinion of cardiothoracic and vascular surgery department was
positioning
advised.
important.
In light of the aforesaid medical opinion, we are of the opinion, we are of the view medical condition of the appellant so-and-so is serious and requires hemodialysis and surgical intervention if opined by cardiothoracic surgeon. Full stop. Interim bail is extended by 3 months. Appellant shall appear before appellant shall appear before the board on 3 months কবে হচ্ছে
Sometimes in May.
ছুটির আগের দিন
20th. Appellant shall appear before the board on 13th May 2025 and further report be filed on the adjourned date. Matter will appear on 19th May 2025. Paper books ready?
Yes, sir.
Paper books are ready. Appeal is shall be placed for hearing in the monthly list of April 2005.
List of April.
Parties are requested to collect the paper books in the
Continue on the same. 19th of May.
7 to 10 are all 7 to 10.
Your Lordship has directed 19th of May.
19th
yes.
আমারটা সেম
আমারটা 9.
সবকটাতেই ডিফেক্ট হবে।
My lord, item number 11, my lord,
Application for suspension of such sentence when the appellant is in custody for 15 years.
One of the appeals relate to 2015. Though one of the appeals was filed in 2024, other connected appeals have been filed in 2015. Let the matter be placed before the Honorable the Chief Justice for assignment. Next. Eighteen to 20.
This is my lord. My lord, I am the Agarpara Company Limited. Agarpara Company Limited in.
My lord, I am appearing for the appellant.
Still the advocate on record. We have no instruction, my lord.
কি বলছে কোনটি
Presented by us.
No, my lord, Agarpara
হ্যাঁ So, my lord, this is my appeal. My appeal. My lord, enough extensions. Lordship, that will be humble submission. There has to be limit to extensions for interim, for time to file affidavit. Last time only expressed two extensions.
After an opposition, he filed positively by 4 weeks. No further extension shall be given. Reply, if any, 1 week thereafter.
Well, give us 2 weeks because there will be 1 dozen
2 weeks thereafter. Matter will appear 6 weeks hence. 4 to 6.
6 weeks.
8 weeks hence. 4 and 2.
Interim order. And the interim order.
Interim order extended by 10 weeks. Date gulo diye.
Madam.
21 man. To the defect of
Yes, Manna.
on the last occasion, Mr. Nundi had supplied me the copy of the
7
report.
lakhs Manna has deposited.
My lord.
Beyond that, there is something, Lord.
My lord,
What he has done, Lord, he has raised 3 bills for 1 word. Supposedly for plastering, Lord, the quotation was 5 lakhs. He has paid the vendor 3 times and then, Lord, reverted the money.
All right, he has deposited that amount.
No, beyond that.
Apart from
my lord, I will.
Manna client is like Manna, my lord.
Why like Manna? What like?
My only looking
Take
for
double.
fish, no meat.
Watch.
My lord,
And
then,
then
Say 27 lakh 20.
my lord, kindly have a look at this document. My lord. This is a copy of. My lord, there are 3 signatories.
That is accepted that he has deposited.
Now the complainant is also a signatory to the checks. Now, it is not a deniable fact that the checks which were issued, the person they have stated here one, Nishikanta Sardar.
What are the double billings? What is the quantum of double?
One is
3 lakhs.
4 lakhs, 5 lakhs, and lot 5 lakhs.
No, my lord,
Not only
5
these,
lakhs.
there are few articles which he purchased from the funds of the
my lord, those are covered under 27 lakhs. That
those are
amount
co-
deposited.
those are-
My lord,
and
these
he
are
has
the
paid
audit
them
reports.
at his home. He pay. Look, there are silver coins. Look, the market price. Look, market price is. Look,
My lord, that was for the 100 years, my lord, gift.
Voucher of
1,500 rupees. So, look,
1,000 rupees.
20,000, 200 things. And he is being chairman, but he is holding all the documents and he has taken away everything to his house. We are not unable to.
No, my lord,
get anything.
the bills are, my lord.
Manna, whatever documents and articles which are belonging to the cooperative society within your control, let them be taken over by police.
My lord, let a search be conducted at my place.
Yes. Let
They're
them
not at home. Not the police. Not when.
But he is confident that there is nothing in his home.
if there is
Any place
nothing,
you want.
then
He should provide whatever is there.
that is why we are saying
Lordship has given him an interim order.
let
So let him go and at
These are the audit reports also.
Now,
Mr.
whatever
Panda,
is having, why
audit report and all is all right. Whatever documents are there with you, you hand them over to the investigating agency if you want the protection of arrest.
My lord.
All right?
My lord.
Report is placed on learned counsels, her learned counsel for the parties. Mr. Manna offers to petitioner offers to cooperate with investigation and hand over documents as sought for whenever sought for by the investigating agency in light of the aforesaid undertaking.
Money trail has not been investigated. Not that is
All right, Mr. Ahmed, enough. Money trail not investigated. All fight for management. In light of the aforesaid undertaking, interim order granted earlier shall continue for 2 weeks or until further orders. Matter will appear 1 week hence.
3 weeks, let him go.
3 weeks until further orders. Matter will appear 2 weeks hence. Further report be filed. Mr. Manna, ask your client to cooperate and hand over all papers.
My lord.
Let the matter come after 3 weeks. Let him let him go.
All right, 3 weeks, 4 weeks. Please hand over documents. Help us to help you.
My lord.
If you don't cooperate, we will take you into custody.
My lord.
इसको अरेस्ट करके वो
charges are 409, 420. Now, my lord, if your lordship, my lord, kindly comes to, my lord, our letters, my lord, addressed to the ARCS Annexure C. Now, my lord, the amount which is stated to be, my lord, there is a shortfall. If your lordship sees our letter dated 1st May 23, we had written to the DRCS Nodia much prior to that, that amount which they alleged has been defalcated has never been received by us. Now, my lord, kindly comes to the first letter,
Where is that letter?
my lord, page 17.
Let us do like this, Mr. Joydeep Rai. Let him sit with your officer and explain the records of the cooperative society, and we keep this matter after 2 weeks or 3 weeks.
My lord, only one indulgence. My lord, I have collected a report from the Nodia District Central Cooperative Bank. My lord, this bank disbursed 7 crores 68 lakhs to the society against my lord self-help group and KCC loan. That entire money has been defalcated. Nothing has been refunded to the bank. And the time
he is saying that these amounts were never received by them. So if he can demonstrate to your client, to the officer, that these amounts were actually diverted before they were received by the cooperative society in the hands of the chairman, he has a defense. But he does not, then appropriate orders will be passed.
But bank says, my lord, already they have given to the society. That is the
how they were given? They were credited.
My lord. That is the my lord. I'm
page 17.
My lord, that is addressed to the assistant register of the cooperative society, and they have obtained loan from the district cooperative bank.
Right. This committee is writing to DRCS.
My lord.
That they had not received this amount.
My lord, kindly see the account numbers in which it was credited. I have placed before your lordship. My lord, kindly see in which account numbers it was deposited, my lord.
But it has to be in the current account of the cooperative society.
Correct. So let them say whether these account numbers were in his control, or it went to some other account.
My lord.
Yes.
Petitioner contends he is the chairman of.
But I am the secretary.
He is the secretary of.
হেমায়েতপুর সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড।
আচ্ছা, হেমায়েতপুর হাজরাপুর সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড, hereinafter referred to as the Samiti. He contends the loans advanced by he contends no money was credited to the account of the said Samiti for disbursal to its members. On the he has been falsely implicated in respect of misappropriation of the said loans, falsely implicated for misappropriation, accordingly praised for anticipatory bail. Learned Counsel for State submit report of the cooperative bank showing the loans credited to various accounts. Petitioner is at liberty. Petitioner offers to cooperate with investigation and explain away the cooperate with its investigation with regard to the loans allegedly the loans advanced by the bank, and establish his defense. In light of the aforesaid undertaking, petitioner we direct the matter to appear how many 3 weeks hence? 3 weeks hence. Petitioner shall not be arrested for a period of 4 weeks or until further orders, on condition that he shall report to the investigating officer at least once a week, and and as and when necessary, and explain the accounts of the society in respect of the loans allegedly misappropriated.
Grateful.
Another indulgence, my lord, the society has been closed since 2023. All the resolution books are in the custody of the secretary, my lord. That should be handed over.
Investigating officer shall be at liberty to recover the resolution book, books of accounts, etc. of the society, and petitioner shall cooperate with the investigating officer in this regard. You don't know who.
I have the petitioner, my lord. Not today, my lord. Only not. Malda, my lord.
Is daddy not there?
No.
That's what it is. Munshi ke paas se to-
May I please, Your Lordship? Your Lordship, this is a case where the main four accused persons have been enlarged on bail by the learned court
Is the
below.
owner
I
of
am
the
the owner.
vehicle, my lord?
What is the value of the
I'm not the FIR name.
Value is not, my lord. 10, my lord, vehicle has been seized with, my lord, sand.
from where was the sand lifted? We want the district magistrate or whoever in charge to submit to report, clarify whether the sand is lifted from an area where lifting of sand is permitted, and if so, what is the royalty on the seized sand? All right. Otherwise, with Priya, no anticipated. Petitioner submit, co-accused are on regular bail. He is the owner of the vehicle. How many vehicles you own out of the 10?
3.
3.
3. Oh.
I'm the owner, Your Lordship. The
Natural
driver has
owner.
been enlarged.
Now, ordinary goods movement, your rate is 1. Illegal hand movement, rate is higher. One seized, further higher. All right. So, owner of the 3 vehicles allegedly used to transport illegal sand. State shall submit report on the following. A. Whether the seized sand had been lifted from an area where sand mining is permitted. 2. Royalty on the whether royalty amount on the, if so, whether royalty amount on the seized sand was paid. 3. Whether the vehicles of the petitioner was used for illegal activity earlier. 1 week.
Okay.
And after 13 years of marriage, the victim wife committed suicide because she was suffering from rheumatic heart disease that is appearing.
Her statement is she was tortured by the in-laws and the husband, my lord.
My lord, kindly consider the
poison and instigated her to consume the poison.
We have considered the materials on record. Petitioners are
My lord, there are three children. They are staying with me. Kindly. I'm petition number 5 is the
husband.
Husband.
Who has
petition number 5 is the husband of the victim lady. Petition number 1 to 4 are
the in-laws.
Her in-laws. It is contended she was suffering from heart ailments and committed suicide. Accordingly, they pray for anticipatory bail. Learned lawyer for the state opposed the prayer. He submits petitioners had handed over poison to the victim
and instigated her to take the poison.
Committed suicide. We have considered the materials on record. Incident occurred 13 years after marriage. Full stop. While petitioners contend that victim suffered from depression due to ill health, prosecution relies on statements. Neighbor statement.
164 statement, my lord.
Let us see. Neighbor statement that she was handed over poison and compelled. Page.
My lord, page 57, 58. 58, my lord.
Compelled to drink poison. Full stop. We have considered the said statement. Petition number 5. The husband is implicated by the said statement. Petition number 5. It is alleged. Petition number 5. The husband had handed over the poison. In light of the aforesaid incriminating material, we are not inclined to grant anticipatory bail to him. However, allegations against petition number 1 to 4, that is the in-laws, are general and omnibus. Accordingly, we are inclined to grant anticipatory bail. Next.
Aksar Ahmed, the headmaster, went with a memo before the school, and it was allegedly it was a fake appointment letter. On being asked, headmaster took my name. Now, kindly sees the memo number 198. Kindly comes to page 10 of my application for a moment. The allegation of paragraph B. 198 was a letter for construction of a wall. That was never a appointment letter.
Page 8.
Page 10. Approval memo number 198.
Page 10.
Yes, of my application.
Memo number 25. Memo number 25 is page 10.
No. But page 10 of my application.
We are looking at page 10 of your application.
No. The paragraph B. Evidently, the approval letter by memo number 198 FSTT APPTT dated such and such, claim to be issued on such and such, appears fake as no such memo used for the purpose of from the office for the signature of such and such things. Now, my lord, kindly seize at the memo number that has been seized by the investigating agency. That was for, my lord, construction of a wall. And my lord, who accused took my name.
That is the original memo. Using that number, a fake document was created for appointment.
Now, my lord, what has happened? And my lord, the complainant was handed over with a memo of approval of appointment of 3 candidates by the principal. That memo was on suspicion.
By not principal, by Aksar Ahmed.
By one Aksar Ahmed, the headmaster, the Pradhan Shikshak. Now, on being suspicious, he asked the Pradhan Shikshak that from where you have got the memo.
Who is the complainant?
The district officer, Biplab Sarkar.
District officer.
Yes. Now, Aksar Ahmed took the name of Bishwarup Bishwas. Investigation revealed that 3 candidates paid 1 lakh in 33,000, 33,000 and 34,000. 1 lakh rupees to one Ajijul. Ajijul transferred it to the petitioner, who was the sub-inspector of police, on UPI platform. There is bank record, CDR. Investigation.
I mean, this inspector of police.
Yes. Sub-inspector of
assistant sub-inspector.
Wow.
Bank records.
Assistant sub-inspector of schools.
Sub-inspector of schools.
Sub-inspector of school, Madrasa.
Madrasa education.
Petitioner submits. He is the sub-inspector of schools, Madrasa education. He is no way connected with the issuance of the fake memo, which was placed by the headmaster.
But may I say this, my lord, once?
Whatever you want to say, we are not going to allow you.
My lord, kindly seize the memo for a moment, my lord.
We will explain your story about memo. All right. Headmaster of the madrasa concerned before the district officer for appointment of teachers. He submits the said memo, the seized memorandum relates to construction of a building and not appointment of teachers. He prays for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. One.
Biplab Sarkar.
What is the headmaster? Aksar
Ahmed.
One Aksar Ahmed, headmaster of Madrasa Shikshak Kendro concern, submitted a memorandum, submitted a memo proposing appointment of 3 persons to the madrasa before the district officer, minority affairs. The memo appeared to be fake and FIR came to be registered. During investigation, the persons named in the memo were interrogated, and it came to light that they had paid money through one Ajijul to the petitioner. Money trail to the account of the petitioner, to the UPI account of the petitioner has been traced. Petitioner strenuously argues that the said memo, that the seized memo relates to construction of building and not appointment of teachers. This is of little consequence. The memo number used in the forged document was the seizure of the genuine memo. The memo number used in the fake document relates to a genuine document, namely permission for construction issued. Who permitted construction? Permission of construct or permission for construction
of a wall.
By issued by whom?
DI, my lord.
Permission of construction by the District Inspector of Minority Affairs. Full stop. The said memo number was affixed to the fake document, and utilized for the for appointment for illegal appointment. Involvement of the petitioner in the said activity is corroborated. Involvement of the petitioner in the said activity is corroborated through the money trail flowing to his account from the illegal appointees, from the prospective illegal appointees. Under such circumstances, we are of the opinion custodial interrogation for unraveling the ramifications of the conspiracy relating to illegal appointments to public posts is necessary, and this is not a fit case to grant answer. Next.
Madam, for the petitioner, my lord. But Magistrate Tribal sections, my lord, charge sheet is submitted. I was not named.
Monday. I'm for the state. Praying for Monday, Lordship.
Magistrate Tribal sections, I am not charge seated. I was not named in FIR. I was charge seated. It is with
consider the materials on record. Petitioner prayer of co-accused Billal alias Mohammad Billal had been turned down.
But it was allowed. Aftab was allowed. Mine was rejected.
Billal is rejected. Had been turned down. Allegations involved stealing, theft of tractors and trolleys by use of forged documents. In light of the
charge against me is with respect to 411. 411.
Recovery has been made.
My lord, out of 31 tractors, 27 has been recovered and charge sheet has been submitted.
All right, not today.
My lord.
Find out whether he stands on the same footing with Billal. Next.
I'm for the petitioner. The petitioner only arrested.
Arrested on 18th.
Filed 14th, arrested 18th. Notice, my lord. After filing this application, the police arrested.
18th.
Arrested?
Yes,
18th. Why you arrested?
14 file, 18 arrested.
So was Anish Kumar was complied with?
No, my lord.
Then we'll issue a rule of contempt against you. Petitioner contends during the pendency of the application, he has been arrested. He further submits that there was no notice under 35(3). BNSS was issued, and the directions in Anish Kumar had not been complied with.
Let me take a report at least.
Correct. That's the contention. Arresting officer shall submit affidavit in response to the said plea. Full stop. Matter will appear 2 weeks hence. Then contempt rule. Then both of them beside each other in jail. Arrestee, arrestor. Next.
Leave the case diary.
Huh?
Case diary is not.
But there is a 354 have sub, but not received till yet.
All right, not today.
Monday. Well, can you take it up on Monday?
Nodia.
Next.
Petitioner was appointed as a driver of a vehicle. He did not give the rent in time.
They have considered the materials on record.
Truck is still untraceable. What I was instruction that truck was sold by the de facto complainant as a scrap.
Not the de facto complaint. That is the allegation. He has sold the truck.
Like that allegation was not raised before
Petitioner
the
had been handed over.
Yes, that is
the
recorded
vehicle
in the order sheet.
No.
For higher charges or against higher charges. It is alleged that he had misappropriated the vehicle. Custodial interrogation for recovery of the vehicle is necessary. This is not a fit case to grant an exception. Next.
There is an altercation between the three ladies with the complainants. I'm the husband of one of the ladies. That's why my name is Taska.
Husband of one of the lady.
My lord, he is the man who assaulted with Da, my lord.
Petitioner submit that there was a skirmish amongst the parties. He prays for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record, including the injury report. Injury report discloses the injury on the arm, a non-vital part of the body. Whether the injury is life-threatening requires to be assessed at the appropriate stage of the proceeding. Accordingly, we are inclined to grant adjournment. Next. But
there is a 164 of the lady, page 27, 28, implicating this petitioner, my lord.
Brother-in-law of the 13th December 2024, brother of the petitioner is divorce law against the
petitioner submits that there was this is a matrimonial dispute.
Yes.
and yeah, husband of the
And who is this person?
He is the brother-in-law.
brother-in-law.
Even the neighbors has implicated him.
Surrender. We have considered materials on record. Petitioner is the brother-in-law of the victim lady. It is alleged. What you are?
Kerala Lordship.
Why? Where working at Kerala?
I am mentioned Lordship.
Mention will do. You are working at Kerala. Then you can say I am working at Mauritius. Show me some documents, sir, that you are working at. That will coming out of your pocket will not do. Will not do. This is nothing. Will not do.
And Lordship on here, Lordship kindly see Lordship on 13th December 2024, brother of the petitioner gave divorce Lordship.
All right, divorce. She is staying there. You misbehaved with her.
12th May 24 is the marriage, and thereafter this.
We have petitioner submit. The brother-in-law petitioner submit. He was working in Kerala. His brother had divorced the lady in December 24 and marriage in December.
Yes, no, marriage on 12th of May 24.
And he has been falsely implicated in the case. He prays for answerable bail. Learned lawyer for the state opposes prayer. We have considered the materials on record, including the statement of the victim. The victim lady alleged she was tortured over demands of dowry. On 3/1/25, petitioner had disrobed and attempted to rape her. Full stop. Petitioner contends, though petitioner contends he was not at the place of work of offense and was working in Kerala, no convincing material. Apart from a bald statement, no convincing material in support of his plea, in support of the alibi is placed on record. In light of the aforesaid facts and the nature of offense implicating the petitioner. Yeah. Well, maybe outrage of modesty nahi kiya hai, thrown her out. We have considered the materials on record. However, it cannot be denied there was matrimonial dispute and possibility of false implication is not wholly improbable. Under such circumstances, we are of the opinion petitioner may be granted anticipatory bail subject to condition, meet investigating officer once in a week. Next.
In order to liquidate his liabilities, one of the complainant, one of issued one check in my favor. I presented the check before the bank that was dishonor. Then I sent notice and then I filed one complaint under section 200 in 138 NIS. But upon receipt of that notice, he refused his liability. And then this case has been started. And
we'll take care of it. Yes.
On instruction, my submission is on 8th he surrendered before the learned magistrate. The CD was called for, my lord. Therefore, it was not found favorable, so he withdrew it, my lord.
Then
we objected to that. Now anticipatory bail filed, my lord.
No way. We will give you liberty to appear and pray for regular bail.
Your lordship kindly.
Mr. Rai, out of question. A man who surrenders, taken into custody, escapes from custody, cannot be given.
But not that, my lord. But it is not.
All right.
But your lord.
Mr. Rai, you press this point. We will make it sure you will not get bail when you surrender. Because we are not going to give you anticipatory bail first. If you are wise, you will withdraw the application. We will give you liberty to appear and considering the nature of transaction, your bail will be considered independent. You want that, we can at best give that, but not this sort of conduct. Petitioner submits. He had de facto complainant. There was a running business transaction between him and the de facto complainant. De facto complainant had issued checks which, upon presentation, were dishonored. The petitioner issued notices of dishonor.
He was my employee.
Petitioner was কি বললাম petition ওটা কেটে দিয়ে বলো তারপরের লাইন
to look after the land of the
all right he full stop he dishonor and in retaliation the present case has been registered. He prays for anticipatory bail. Learned lawyer for de facto, senior advocate for de facto complainant contends petitioner had appeared before the jurisdictional magistrate. He had been taken into custody and thereafter he surrendered before the jurisdictional magistrate. Case diary was called for. Thereafter, he withdrew the application for surrender and has prayed for pre-arrest bail. We are of the view, we are of the view, once petitioner had appeared before the jurisdictional magistrate, he had been taken into custody by the said magistrate. It was not within the domain of the petitioner. Thereafter, it was not within the domain of the petitioner to withdraw the surrender application and prefer pre-arrest bail. To permit him to do so would amount to turning the hands of the clock back and erasing a arrest already done by the magistrate. Full stop. Needless to mention, relief under anticipatory bail is a protection from custody upon arrest, which cannot be contemplated when the petitioner had earlier been arrested but illegally released, but had illegally escaped from the process of law. Full stop. In light of the aforesaid circumstances, learned counsel prays to withdraw the application and appear before the magistrate and afresh and appear and pray for regular bail. Accordingly, the application for anticipatory bail is not pressed. In the event the petitioner appears before the jurisdictional magistrate within 7 days from date, the learned magistrate will consider the prayer for regular bail afresh without being influenced by the earlier conduct of the petitioner and bearing in mind the nature of transaction and necessity of custodial interrogation.
Well, bearing in mind, so far,
one thing,
nature of the transaction.
Your lordship kindly paid on page 20.
Mr. Bhattacharya, if it was not his conduct, we would have considered it prayer.
Your lordship,
I think 3 days before, my lord.
Page 20. But what is staring in my face, my lord? The police is coming that I am not complying with 41A notice. And what is the reason? Police is asking me to hand over the original check which the
I have, Mr. Bhattacharya, we have indicated the magistrate will consider the nature of transaction and necessity of custodial interrogation.
This is my
and we please, Mr. Rai.
I have heard, my lord.
For the petitioner.
302.
Malad, yes, Malad, 24 accused
302.
Malad, out of
302.
Case of July 23,
rivalry.
Any rival.
9 persons, some of the persons granted anticipatory bail.
They are named transfers either in 164 or in 161 of the eyewitnesses.
Statements of witnesses implicate the petitioners as members of the group who assaulted the victim, resulting in grievous injury and death. It is contended that they have been falsely implicated due to political rivalry. Good stuff. In view of the gravity of offense and the statements implicating the petitioner in the crime, we are not inclined to grant answer. New political rivalry or old political rivalry?
No, my lord, it is the new political.
New political rivalry.
Received the case diary from Malda Mala just now. Received the case diary.
And for the de facto one.
There is a rivalry between the parties. They are the prisoner and the de facto complainants are the family members. There is a dispute.
All right, we have considered the materials of the court.
They assaulted brutally.
Victim has been recovered. Petitioners are not the principal accused. Accordingly, we are inclined to grant answer.
Applies to.
Next.
De facto वकालत ना
But I am appearing for the NCB led by Mr. Arun Kumar Maiti. Our paper book is ready.
Appellant has undergone 12 years of is in custody. Appellant is in custody for 12 years and has undergone substantial portion of the substantive sentence, that is 15 years, imposed on him. Though paper books are ready, there is little possibility of the appeal being heard out in near future. Full stop. In light of the aforesaid situation and the law declared in so and so blank that prayer for suspension of sentence on the ground of protracted detention infracting Article 21 is not fettered by restrictions under 37 of NPS Act. We are inclined to suspend this sentence. Next.
45 Lordship praying for not today because Lordship the appellant's father passed away. That's why I only pray for interim bail Lordship.
45. File a supplementary affidavit. Not today. Next. Why 47 not today?
47 not
Lord, 300 to 376, 511, Lord, the life in
Out of 12 years, my lord, petitioner has suffered 7 years, 2 months, 70 days, 17 days.
For the state in 49. Conviction?
Conviction is 20
PIIT.
12 years imprisonment.
6 kgs of choros was found from the joint possession of 3 persons. My lord, there are 6 witnesses, including the independent witness, the raiding team, as well as the not this week.
But one thing, my lord, maybe committee, my lord, the option, joint option was given to the detainees, my lord. In terms of permanent, my lord, your lordship.
Parmananda is forgotten. Parmananda is no longer binding precedent. All right. Now you are. We'll dispose of your. Any other point? Argue next week we will discuss.
Next week, not this week.
Who is appearing? Abdul Rashid.
দেয়নি এখনো মানে এখনো দেয়নি
Amita Ghosh.
Amita Ghosh is for state.
Kasim Hasimi.
Please, Amita Ghosh, please inform Kashim Hasimi on the next day.
Item 50 তে তুই স্টেটের আছিস এনাকে একটু খবর দিতে হবে
নাম্বারটা জোগাড় করিয়ে
Yes, next matter.
নামটাই তো
নেক্সট সেকশন
Relate to item number 2, 3, 4, and 5.
My lord, in the morning, Lordship was pleased to suspend the sentence in respect of item 5, where he had suffered imprisonment for more than 16 years. They have a cran in item 2. They couldn't point it out then. That is why they're bringing it to your lordship.
Please indicate whoever to the officer. Or we'll make it not today, tomorrow.
My lord. Not today, kori kalke eksange kor.
2, 3, 4,
2, 3, 4, 5.
The problem, so this is the problem. Nobody.
That already been placed.
Yes.
So, so far Nimai Chudhuri is concerned, but in my humble submission, there is hardly any evidence against Nimai. You also wanted by non-defense to point out the evidence with regard to Dulal Bondo.
So you don't want to make any further submission?
No, only your lordship wanted us to file a written notes of argument. What are thinking? Written notes of argument টা কোথায়? এইটাই তো। হ্যাঁ, জজ সাহেবদের জন্য ডাক দিয়েছো কেন? Prepare a written notes of argument.
All right, we'll keep it next Thursday.
Next Thursday. আরে এইটাই জজ সাহেব।
Submit their argument. Hear you.
আমাদের
Next Thursday.
স্যার আমি একটা কপি পাবো না?
কি দেবো এই ওকে একটা কপি দিয়ে দিই।
আমি এখন দিয়ে দিচ্ছি ওনাকে।
কেন?
After 2 p.m.
May I be permitted to mention, my lord? My lord, on 9th of January, my lord, my application was supposed to come today, my lord. My lord, but it is not appearing in the list, my lord. It's a Ponzi matter.
But one matter I'm mentioning, my lord, two matters, my lord. Actually, what is going on, since there is no injunction order, the Ponzi matters, my lord, and the company is selling the properties.
Which are the companies?
Company board?
Freedom Group.
Freedom Group.
Freedom Group.
Okay. You give the numbers, we'll post them. Call the list.
লিখে দিচ্ছি।
Madam, I'm appealing for the
Mr.
But yesterday, my lord, I had.
Okay, General, your secretary is online?
Yes, she's online, my lord.
All right.
Lord, we have prepared, my lord, a status report, not in the form I wanted, but kindly excuse us. But please have a look to my paragraph 6 first, on the first page. Then, my lord, AC portion, your lordships may skip. In the second page, my lord, Roman 5.
Roman 5, right?
Yes.
6 vacancies.
Yes. Then kindly have a look at paragraph 8 on the third page. Milord, paragraph 9 is, Milord, we have the figure is not very important. What is important is, Milord, 100% of the budgetary allocation, Milord, has been disbursed from the year 2017-18. Then para 10 is, Milord, the additional posts that are sought for. Milord, para 11, 12, Milord, are reiteration of whatever, Milord.
So far as paragraph 8 is concerned,
yes, Milord.
Our view is, if someone cannot be re-employed, then someone can be
Yes, that will be done. That will be
in
done.
his place. But the thing is, the post should not be kept vacant,
Right.
because the number of posts are not that substantial. And if you have just 2 staff and 1 staff is not available, then the running of the committee becomes a challenge.
Yes, it will be done, Milord. Maybe a month or so.
It will be done. And the additional post that
that would, Milord, take some time, but kindly see, Milord, paragraph number 11. No, I'm sorry. Paragraph number 8.
8 we have seen.
Yes. It would take some time, Milord.
Paragraph number 8 is with regard to the reappointment.
I'm sorry, paragraph number 10. Sorry.
10 we are seeing.
Yes, 10.
10 we are seeing.
Yes.
Now, what we feel, particularly 3 and 4, they are very vital. The stenographer,
yes,
to the
yes,
one stenographer and the data entry operator. What is happening is,
just give me a second, Milord. I'll take it. All 24 filled. But as of now, Milord, I'm told the vacancies in respect of the existing strength has been filled up.
Filled up.
Filled up. That is 24. 24 out of 24 is in place.
Vacant positions have been filled up.
Filled up. That is my immediate instruction.
All right.
So far as the additional posts, Milord, that has been.
What we are proposing, Mr. Advocate General, is of the 4 proposals, kindly see proposal number 3 and 4.
Stenographer and data entry office.
The stenographer is very essential for
yes, I don't
the working of the committee. B, The data entry operator.
No,
if
there
at
are
least
6
not
already
4,
working. 6 already
It's
working.
not 4. It needs, I tell you, the reason why it needs to be beefed up is all the applications and everything is now done online. And each of the companies, there is a gargantuan data which is required to be entered, dealt with, and processed.
But everything will be put in place. Give us some time. My lord. At the earliest, it will be done. But
54 companies have been referred, and no nodal officer is
Let this be done between the lawyer of the committee and the advocate general. All right.
But there is no address on the post of nodal officer.
Huh?
No appointment or no whisper, my lord. How would the nodal officer be appointed?
Where is the nodal officer post?
My lord, I had handed over, my lord, the vacancy.
No. Mr. Advocate General, would you give Mr.
a copy দিয়ে দিও
a copy? Is there was a nodal officer?
No, this is what we have, paragraph number 10, subject to correction. These are my instructions.
I think this is the Mr. Ahmed, please share your.
Yes, I should. I'm sharing with him. So far, my lord, this is in respect of their proposal of filling up the posts.
Correct, but please give it to them.
I have given
them. Section officer 3 is filled up according to them. PA2 chairman 1 is filled up.
আপনাদের কাছে কোন নোডাল অফিসার এই আসে রেকুইজিশন আসে
সুব্রত মিত্র was appointed. Subrata Mitra. He also nodal officer.
কি বলছে সুব্রত মিত্র নামে কেউ অ্যাপয়েন্ট হয়েছিল
UDC. There's one nodal officer, Mr.
Yes, the serial number 1.
Yes, this is not in the staff strength that you are giving in Roman 5.
Yes, it's not there.
Please compare these two. Please compare these two.
But in my paragraph number Roman 5,
your officers don't instruct you correctly.
In the place of nodal officer,
yes,
I find Millard in paragraph Roman 5 joint secretary.
You are describing him as joint secretary.
Maybe I'll have to check it out.
It seems so, but please check it out.
Yes.
I don't think they would give an incorrect instruction.
Yes, I don't say so, Millard.
Because assistant secretary, no, this
assistant secretary in both the
now in your chart there is joint and deputy secretary.
Yes.
Now these two are not there in their chart.
Right. Then assistant secretary 1 in both the tables.
Ahmed, please sit with the advocate general and his junior and work out the staff pattern that you are giving and the staff pattern given in Roman 5 don't tally.
No, I believe
Registrar
subject to
original
correction. I believe subject to correction. This is the vacancy list. And what I am showing at Roman 5 is what is the sanctioned strength for the vacancy on the right hand side.
Correct. Even in the sanction strength,
yes.
What
we don't find a nodal officer.
The nodal officer is missing.
Right.
So a nodal officer, I remember there was a nodal officer who was a retired judicial officer.
Yes. Subrata Mitra.
No, against him, I think now Mr. Arun Kumar Nandi is there.
He is the joint secretary.
He is the joint secretary.
Is the joint secretary? Joint secretary to what? To the committee?
No, this is the appointment of the nodal officer, my lord. And after he relieved himself from the post, we had made my lord the present.
A nodal officer ব্যাপারটা একটু ক্লারিফাই করবেন তো?
Just see the appointment letter.
But I'll check it up.
We had forwarded the name also on this date, 17 January 20. I will share with you.
What we are doing as of now, Mr. Dotto is we've placed on record a report. Let it be handed over to Mr. Ahmed, and we request Mr. Ahmed to interact with your office, and you please submit a further report with regard to filling up of vacancies, consideration of new posts, and other infrastructural issues on the next date. Correct?
But additionally, my lord, may I propose one thing? That my officers will meet the chairman.
That is what we
Yes.
expect that.
Yes.
But then we would, in our order, say that Mr.
Yes, yes.
Ahmed would interact with your office and your officers.
In fact, my lord, I had interacted with Mr. Ahmed. He knows that I called up the officers. Unfortunately, but these were not percolated to the court.
From the bench, we don't want to go into the apportionment of responsibility as to
Yes, yes.
where
No,
the
things
issue,
are required to be done. It will be done.
where the issue stopped. We needed to put some degree of urgency, which is why we asked the secretary to be present and you to be personally present. And if that has its impact, we will be happy. If it does not have an impact, we have to be more aggressive, and which we don't like to do.
Well, before your lordship, my lord, parts with it. Your lordship will kindly see, in the garb of compliance, my lord, I'm just handing over to these two files. The two terms of appointments after the constitution of the committee. The terms were totally different. And now, my lord, only for 6 months. It was earlier, my lord, 65 years, up to 65 years, or on termination of the committee, or, my lord, I've just, my lord, presented before your lordship, my lord, 1, 2, and 3. 1, 2 are, my lord, the first appointment letters, the terms. And now your lordship is, after your lordship had, when I called upon to explain why appointments were not made, this came last night with the rider only for 6 months. Why the deviation of the terms of the appointments? 6 months means, my lord, if I start, before I can take up I train the persons, again I have to go with the bound, I'm begging for another appointment or extension. Was this the purpose for which I mentioned before your lordship?
One
Chairman.
Now this person has crossed 65.
This person has not crossed 65, my lord. Here is only for 6 months. That means, my lord,
if the temporary employee is not crossing 65, then your clause 8 does not apply. Then why don't the terms of appointment be till 65 or the termination
May I
of
know the gentleman's name?
Shannal.
Some
Devashish Shannal.
All others, my lord, who were appointed pursuant to your lordship direction.
He retired in 24. If he is retired in 24, then the question of his crossing 65 doesn't arise.
Yes.
So it may be till 65.
We'll work out, man. We'll work.
Please work this out. We understand this sort of an appointment may be post 65, where you say that you require the relaxation of your memo. But in cases where it is between 60 and 65, why don't you appoint till 65 or termination, whichever is earlier?
Right.
That saves your troubles, saves the trouble of the committee to continuously make to and fro communications.
And that also, that was the term in the earlier, the first order.
We've seen it. Mr. Look into this. Learned Advocate General, Principal Secretary is present online. Full stop. Learned Advocate General submits status report with regard to the vacancy position and other issues. The report shows that the remunerations of that steps have been taken with regard to the disbursement of remunerations of the former as well as the present honorable chairman. Stop. 6 vacancies in sanction strength. 6 vacancies as per sanction strength has been filled up. The committee has received request for creation of 8 additional posts. We are informed that this said proposal is under active consideration. Mr. Ahmed submits the appointments to the posts have been made for a period of 6 months, which disrupts the smooth running. 6 months instead of 65 years or termination of the committee, whichever is earlier. Full stop. The 6 monthly appointment of employees adversely affect the smooth running of the committee. Learned Advocate General assures this court that corrective steps shall be taken in this matter. Mr. Ahmed also brings to our notice the post of nodal officer is not reflected in the sanctioned strength in the status report. Full stop. The post is vacant. Learned Advocate General is directed to look into the matter and make appointment to the said post as soon as possible.
Not only one interruption. Please have a look to page number 9 of my report. Mr. Shanyal is, whichever is earlier or until further.
That is the
para
problem.
2, para 2.
We have seen.
No, whichever is earlier or until further orders of the government.
So that is why we are saying 65 years, whichever is earlier, makes it 6 monthly.
Whichever is earlier or until further orders.
Until further orders is a very generic expression. Please delete that 6 months. Make it earlier orders where up to 65 years or termination. You make it also or other further orders of the government. But the grievance expressed is if it is on a 6 monthly basis of whichever is earlier, by the time the mandate comes, again they have to prepare a file for extension. What happens is a temporary reprieve for the government to pay salary and a terrible agony for the reappointed employee. If you want to make the appointment unattractive, this is a good technique. But if you don't want to make it unattractive, I think other conditions are better. As soon as possible. Full stop. Further report be filed on the adjourned date. Full stop. Presence of the Principal Secretary. Online presence of the Principal Secretary is noted and dispensed with as of now. Stop. We keep this matter after 4 weeks. Good. Really?
Law matter.
Yes.
No lawyer for the state. The replies are not coming forth. Finding it very difficult.
But I'll make arrangements.
I have passed an order whereby I have indicated, but please.
But I'll make arrangements.
You have too many people, but too few lawyers.
Exactly.
I'm told you an enormous list of impaneled
see
lawyers.
What happened before this court in this matter on the last occasion?
That is. We do not wish to burden you. That's why we didn't call you. But there were certain things which were very disturbing. The present chairman was feeling very exasperated. And that's why we needed your assistance. And we also needed the cooperation of the principal secretary. Thank you.
At 4028/2017, the interim order is expiring next week, 28 February.
Interim order is extended for 4 weeks or until further orders.
No, my lord, those persons who were appointed on these terms, there is 6 months.
Sir, that will be taken care of. Next time when they do it, it should, in our understanding, ought to be 65 years or till the termination.
So we should allow them to join, my lord, subject to the result of this.
No, definitely will allow them to join. Why won't you allow them to join? If they are re-employed, they will join. And now there's a mandate for 6 months. In the meantime, the next extension should be up to 65 years. If it is not so, or any further extension is not so, bring it to our notice. Thank you.
Today is the date for Rose Valley matters. Next week it will be taken up.
Next week, I got এখানে ও আছে এটা তো ইয়ে হ্যাঁ right.
In fact, what you know from 64 to 89, the specific nature of what better training is. And what I read about those posts, the skill level is very essential for
And data entry operator also.
thank you for if one of you can be that is very important. And a nodal officer. What is happening is during the absence of the nodal officer, the honorable chairman himself has to in certain cases, not in consequence.
Yes.
Thank you. Call the list. Item number 1.
I am item number 1, my lord. I am for the petitioner, my lord.
Yes.
For my lord, for appropriate order have passed this order, my lord, petition. Actually, my lord, your lordship opined that the grievance was not placed on the proper time. So, my lord, I have placed on that very date. I made application before the learned trial court that I was not properly treated. I was abused, and my lord, adverse comments were made in the open court. As I am an advocate, that is why, my lord, my evidences was not properly taken. But I was highly humiliated.
Where is your application before the trial court?
Yes, my lord, I have annex, my lord. Annexure P1.
When?
Paragraph number 4, paragraph number 7, my lord, I have written.
Where is the order sheet on this application?
This application was filed, but actually no order was made.
Can't be. It was not moved.
It was, my lord,
latest
certified copy, my lord.
Maybe a certified copy. 25A.
A report may can be called for, my
No way, nothing.
But if your lordship direct me, then I will submit all the certified copy of orders and
So your certified copy of order is in the main petition.
orders and all petitions I will submit by way of supplementary affidavit, my lord.
Why should we?
But actually, my lord, she is not getting any justice, my lord. That is why, my lord.
We are not concerned. Petitioner has prayed for recalling of order dated 24/9/2024, whereby this court dismissed her prayer for setting aside, dismissed her prayer for transfer of the proceedings from the file of Judicial Magistrate Second Court, Barasat. Full stop. In the recalling application, petitioner has indicated that she had made application before the trial magistrate with regard to the adverse comments made by her, but no steps were taken. I have gone through the application annexed to the annexed to the application praying for recall. Full stop. Your interim maintenance application has been disposed of. How much maintenance has been given?
Well, at only 2,000 for my.
Have you challenged that order?
Yes, I have challenged.
When the order was passed?
But when the order was passed, after 1 year from the date of filing this application.
The order will relate back from the date of the filing of the main interim application. So there is no.
Several petitions were filed before this honorable court. Honorable court directed to dispose of the matter, my lord. That was not followed also.
Sir, the relief has been granted to you. Maybe not up to your expectation, as a lead for enhancement. You will annexed to the petition praying for recalling. In the said petition, in the said application, it is contended that it is contended in spite of directions given by this court to dispose of the prayer for to dispose of the prayer for interim maintenance within a specified time frame. The magistrate failed to do so and observed that the litigant may approach the High Court for necessary order. Full stop. The observation of the magistrate is not an expression of bias. Now, one must bear in mind the heavy pendency in the file of each magistrate. Judicial officers are overworked, and directions for disposal within specified time overwork, and the apex court in so-and-so versus so-and-so held direction for disposal, held time frames for disposal of proceedings is not warranted. Be that as it may, warranted. The other issue canvassed in the petition is an incorrect recording of date in the petitioner's deposition. The said issue may be agitated in the course of final hearing of the petition. In light of, however, the averments in the application, in my opinion, does not make out any case of bias against the petitioner, which would call for transfer of proceeding. We are informed that interim maintenance has already been awarded and the same has been assailed by the petitioner before the revisional court. In such view of the matter, we do not find any reason to interfere with the order dismissing the application. Dismissed.
Any further direction, my lord?
Nothing.
I love Leicester, my lord.
Next.
I love Leicester, my lord.
Item number 2.
My lord, I am appealing for the petitioner. But I have prayed for expeditious disposal of a proceeding, my lord. The FIR is that.
Who are you?
I am the de facto complainant.
What is the status?
Well, the status is charge sheet has been submitted, and thereafter ER is pending for certain accused. My lord.
Huh?
ER execution.
Petitioner submits that there is delay that the proceeding that he is the de facto complainant and the proceeding is pending before the trial court since 2023. He prays for expeditious disposal of the case. Mr. Bhattacharya, learned counsel for the state, is requested to appear in the matter. Copy of the petition be served upon him. We have gone through the materials on record, including the order sheet annexed to the petition. We notice some of the opposite party accused are absconding and execution and warrant and the matter is pending for execution return of warrants issued against them. Given this situation, we dispose of the petition, directing the learned magistrate to take necessary steps for execution of the warrants against the absconding accused, and upon the said accused appearing before the court, or in the event their attendance cannot be procured in spite of exhaustion of processes, being declared as proclaimed offender, to proceed to the next stage of the proceeding and take the proceeding to its logical conclusion at the earliest.
Great. The difficulty is some public money is involved. That is why we came up with this application.
No, that is all right. But then what can we do? This is the if accused were there, then we could have at least given them protection. Next.
Appearance. 3.
Petitioner husband has assailed judgment and order dated so and so, passed by learned magistrate, directing payment of maintenance at the rate of rupees 4,000 to the opposite party wife and minor daughter, 4,000 per month, and litigation cost of rupees 5,000. Petitioner was married to opposite party wife on 2/2/2009 as per Special Marriage Act. From the wedlock, daughter was born, a girl was born on 30/8/2012. Opposite party alleged she was subjected to torture by the petitioner and other in-laws and compelled to leave the matrimonial home on 22/2/2010. আচ্ছা, এইটা বলে thereafter she returned to the matrimonial home in January 2012 and a daughter was born to the couple in August 2012. Unable to bear, however, the torture continued, and unable to bear such torture, opposite party wife took refuge at the parental home with the minor child. The child is a student at St. Margaret School, and it is claimed that she has to incur expenses of rupees 7,000 per month, education expenses of rupees 7,000 per month. Opposite party claimed petitioner is a manager of a jute mill and earns rupees 50,000 per month. Affidavit of assets were disclosed by the parties. In the affidavit of asset, the petitioner claimed that he is employed at a monthly salary of 13,821 and has a general expenses of rupees 6,000. He has to take care of his aged mother. Balancing the requirements of the opposite party wife and a growing child, including her educational expenses with the earning capacity of the petitioner and his general expenses towards himself and his dependent mother, the magistrate directed payment of rupees 4,000 per month as maintenance towards the opposite party wife and the minor child, as well as litigation cost as rupees 5,000 payable in 2 installments. Quantum of maintenance is commensurate to the needs of the opposite party wife as well as the minor school-going child, and takes into consideration the requirements, the general expenses quoted by the petitioner in the affidavit of assets. Hence, we do not find any illegality or impropriety in the order. Application is dismissed. Next.
Your Lordship, Mr. Uday Shankar Chattopadhyay is appearing for the petitioner, Lordship. He is engaged in courtroom number 17. I'm praying for not today, Your Lordship.
No.
Then, Lordship, kindly give us short passover.
No. Petitioner contends he is not the signatory of the check, and the proceeding কি আবার কি Total Shingo complaining. Why you are challenging it? Petitioner contents petitioner is complainant contends that the revisional court erred in law in holding that the of prosecutions launched in respect of 3 dishonored checks would not be tried together. Let the matter appears contested application 4 weeks hence. Copy of the petition be served upon opposite party number 1 and 2 through registered speed post. There shall be stay of proceedings in CR number 58 of 2020 for 6 weeks or until further orders whichever is earlier. Next.
I am the petitioner. The 125 application since pending 2014 along with the interim application. PD disposal required.
Petitioner is the wife.
Petitioner the one.
Why it is pending so long?
One after one fabulous application filed by the opposite party.
What frivolous application was filed?
My lord, he filed a complaint case against me, annexed here to E. Annexed here E. My lord, Justice Sampadatto Paul dismissed the said CRR application, quashing. Next D should be next.
You are a teacher. You are a teacher. You have known sorts of income.
Para teacher, part-time para teacher. One male child or one daughter they are in. Opposite party is a doctor, and you are doctor.
Petitioner has instituted a proceeding under 125 CRPC. Petition press for expeditious disposal of proceeding under 125 CRPC, wherein she has paid for maintenance from her husband. She contends parties were married to each other. Where is your 125 petition?
125 applications.
Parties were married to each other and
It's a Shiva.
Page
15.
Parties were married to each other on 11th May 2024.
2004.
2004.
2000.
Yes. And from the wedlock, a female and a male child were born on 23/3/27 and 23/3/2007 and 16/11/2009. Petitioner was subjected to torture and driven out of the matrimonial home. Opposite party is a homeopath doctor and earns rupees 50,000 per month. She prayed for maintenance / interim maintenance at this rate of 10,000 rupees per month and 10,000 for herself and 15,000 in all for the two minor children. The proceedings are pending since 2014. I have gone through the material. I have gone through the petition as well as the order sheet. Petitioner has also filed a case under section 498A, 406 of the Indian Penal Code, criminal prosecution lodged under section 197, 199 IPC, alleging that petitioner filed by opposite party husband, alleging petitioner had made false averments, has been quashed in CRR 1134 of 2020. 2019 interim maintenance application is still pending for consideration. Under such circumstances, in view of the nature, there is a revisional application which has been filed.
The opposite party.
What revisional application?
One motion challenging the order.
Which order?
Interim application petition 2308/2016 pending. The challenging the said application is a preferred revisional application.
What revisional?
Huh?
What number?
Number page.
Is there any stay in the revision?
No. That matter also be disposed. That matter also dismissed by the 18th edition. Already dismissed. 13/3/2020, the Learned NGM.
Very clear. Yes, what was the impugned order of 13/3/2020?
Page number 81.
Page
number 80.
80.
Page 80.
কি বললাম না তার আগে বলো opposite party preferred an application for dismissing the prayer for interim maintenance, which was dismissed by the magistrate video order dated 13/3/2020, and the same was affirmed by the additional sessions judge in criminal motion number 15 of 2022.
Opposite party filed this application rejection of the plaint.
That's not rejection of the maintenance application.
Reject of the maintenance application. Opposite party filed that application. That application has been dismissed by the 10th JM.
Against that order, any revision has been filed?
Against that, no. There is no
nothing.
Nothing.
Now date has been fixed for what?
In lower court. There is a hearing.
Hearing of what?
Hearing interim application. Interim application should be hearing now.
Page 78, what is this order? OP will an interim. The interim maintenance application is still pending consideration. Under such, in view of the nature of order, I propose to pass. No notice need be served upon opposite party. We, in view of the as the interim application, interim maintenance application is pending for a long time. Under such circumstances, we direct the magistrate to dispose of the interim application as expeditiously as possible, preferably within 60 days in view of the proviso to section 144 BN 125 CRPC. Without granting unnecessary adjournment. Next.
My lord, I am for the petitioner. My lord, the husband, the mother-in-law, and the sister-in-law are before my lord seeking quashing of the proceeding under section 498A, my lord. My lord, marriage 2013. The wife on own volition 2015 left matrimonial home. 2018, the husband obtained the restitution of conjugal rights decree, my lord. She did not come back. That year itself, she filed the divorce case, and also before the learned magistrate, the maintenance proceeding I have been paying, my lord. Now, my lord, in 2020, she has filed a 498A case. My lord, charge sheet have been submitted.
Petitioner submits that the opposite party wife deserted the matrimonial home in 2013. 2015. Petitioner number one husband filed a suit for restitution
2018.
In 2018, which
and got the decree,
which came to be decreed. Thereafter, in 2020, impugned criminal proceeding has been maliciously instituted. In light of the aforesaid submission, petitioner has made out a case of belated institution of proceedings in a malafide manner. There shall be matter will appear 4 weeks. Copy stay.
I'm ready.
Next.
Item 7, my lord, I'm led by Mr. Amurtha Ghosh. He's appearing virtually, my lord.
My lord, can your lordship hear me?
Yes.
Yes, my lord, the petitioner of your lordship, my lord, he is the director of a company. He purchased a duplex from another company in the name of his company itself. Now, my lord, after the purchase went very smoothly, there was no problem. Suddenly, my lord, the petitioner received certain communications where he was asked to return the keys and hand back possession. Now, this, my lord, the petitioner was not agreeable to this. Although, my lord, the money paid for the as consideration was refunded to the petitioner's company. That's a matter of fact. Now, my lord, what has happened? As soon as he received the communication, my lord, he wrote back, he sent a legal notice saying that I am seeing that somebody else is in possession. The petitioner came to know, my lord, Mr. X has been handed over possession by the opposite party complainant at a higher consideration. As soon as my lord legal notices were exchanged, this complaint was lodged by the complainant. Now this my lord complaint has been investigated. Petitioner responded to the notice of appearance. Charge sheet has come my lord under 447, 323, 500, 506. If your lordship kindly sees the complaint, there are no my lord allegations. Petitioner had allegedly threatened the complainant over phone. Now my lord, in the charge sheet there has been no seizure, no call details, nothing. Petitioner has also allegedly sent goons to rough up the complainant. No one has been made an accused. And my lord, so far as the trespass is concerned, the only my lord cognizable offense, it has been attributed to the agent of the petitioner. That is the specific case. All the other offenses, my lord, are non-cognizable, so far as the petitioner is concerned. Petitioner has also informed my lord Hare Street Police Station, although it is a counter blast, nevertheless.
Petitioner contends that there is dispute between the parties with regard to the ownership of the flat, allegation of threat, ownership of the flat, allegations of threat, and allegations of destruction of property and threat are bereft of material particulars. There is nothing on record to show that the petitioner had illegally trespassed into the property. Ingredients of the alleged offences are not disclosed. In light of the aforesaid submission, I am of the view petitioner has made out an arguable case in his favor. Let this matter appear 4 weeks hence. Opposite party, public prosecutor, opposite party number 2, through register speed post, there shall be stay of proceedings in GR number so and so, 6 weeks or on.
Grateful, my lord. Grateful.
Challenging the ex parte order and judgment, my lord, I filed one appeal. Appeal has been dismissed for default on the day of survey para. My lord, on restoration, I filed one application for restoration. That application has been rejected. That order, my lord, kindly come to page number 61, 28th June 2024. My lord, I want the restoration of this of the appeal.
What appeal?
Appeal of the domestic violence.
Give notice. Copy of the petition be served upon opposite party. Opposite party number 1 through registered speed post and 2 through public prosecutor. Matter will appear contested application 2 weeks hence. Next.
My lord, item number 9, my lord, I am for the petitioner, my lord. My lord, the application for quashing of proceeding, my lord. Allegation are, my lord, 354A, 506, 509, and 34 of the IPC, my lord. My lord, kindly see the, my lord, annexures, my lord, and the complaint, my lord. Totally a civil dispute, my lord. The complainant, my lord, intend to, my lord, use the petitioner land. For that, my lord, the complainant file a writ petition before this honorable court, my lord. Kindly see, my lord, page 61, my lord. After that, she lost the complaint before the police station.
Where is the charge sheet?
My lord, the unmarked copy, my lord, certified copy is there, my lord.
Where is the charge sheet?
My lord, the certified copy, my lord, is
certified copy. Acha. Discharge. Preferred discharge petition. The mobile phone showing the obscene act has been seized.
There is the allegation of 509, my lord.
Not only 509, there's an allegation of 354A. All right. And we find from the property seized, the mobile phone is there. So you liberty to pray for discharge. All right. Before, let the magistrate see the electronic record.
Yes, sir, lord.
All right. Contents, we have produced the impugned charge sheet. In the charge sheet, it is alleged with petitioner has illegally trespassed on the opposite party's land and had raised raised cement pillar and bamboo fencing. When protested, one of the petitioners threatened and intimidated the opposite party, and one of them raised his wearing apparel and flashed his private parts to the opposite party. The incident had been video recorded. In charge sheet shows in conclusion of investigation, charge sheet has been filed. Perusal of the charge sheet would show electronic evidence in the form of mobile device. Electronic evidence stored in the mobile device has been seized. Full stop. Petitioner submit that the allegations are false. Submit that there is a pending civil dispute between parties and the allegations are false and concocted. In view of the fact that the allegations in the charge sheet, in view of the fact that investigation resulted in collection of electronic evidence in support of the charge sheet, it is I am of the considered view the grievances expressed by the petitioner requires to be looked into by the magistrate in light of the materials collected during investigation. Hence, I do not wish to interfere with the impugned proceeding. It is open to the petitioner to agitate his grievances at the appropriate stage of the proceeding, including the stage of consideration of charge, if so advised. Next.
This is a revision preferred by the state. In a trial, there were 67 witnesses. After 34 witnesses were examined, an application under 311 was filed before the learned Fast Track Court 1 at Boshirat, praying that we would adduce 5 more witnesses out of the remaining 33, and recalling was prayed for, and issuance of fresh summon was prayed for against 9 witnesses who were not named in the charge sheet earlier.
Are they in custody?
They are in custody, my lord. There are 71 adjournments were taken, my lord. If your lordship kindly sees the
please give notice.
Order, my lord. Yes, my lord. Kindly let me serve. They are in custody, and
if they are in custody, why should
no one is appearing for them now? The trial has been fixed on 28th of February, and the legal aid, London advocate has been appointed from the legal aid so that they contest the hearing.
There is a direction.
Yes, my lord. Direction is there for expeditious trial. The court is lying vacant. The fast track court, Boshirat, is lying vacant soon after passing of this order. Since then, no witness could be examined. But now the matter is supposed to be taken up by the third first track court in charge of the first one, first court. The 3 police officers were injured, sustained bullet injuries. They were treated at the Apollo Hospital.
Then
9 doctors of Apollo Hospital are to be examined. That the
petitioner states prosecution submit that application that the prayer under that learned trial judge illegally turned down the prayer for examination of witnesses who are vital for a just decision of the case. We note opposite parties. We note opposite party accused are in custody. Copy of the petition be served upon the opposite party accused through personally through the superintendent correctional home, and affidavit service be filed on the adjourned date. Superintendent correctional home shall interview affidavit তারপরে এটা আগে দিয়ে affidavit. Superintendent correctional home shall intimate the opposite party number 1 to 5 of their right to legal representation through High Court Legal Services Committee, and in the event they are willing to be so represented, communication be made to the Secretary of High Court Legal Services Committee for appointment of counsel on behalf of the said opposite parties. Matter will appear 2 weeks hence under the same heading as 2 weeks hence.
Great.
Next.
Your Lordship, in this matter, I am appearing for the petitioner. Your Lordship, I am praying for the quashing of the proceedings. Your Lordship, the de facto complainant, being opposite party number 2, namely Bolai Manna, has written in his written complaint that he has given a sum of rupees 17 lakhs to one Babul Mondol for the appointment of his 2 sons in the government office. And in that said written complaint, Your Lordship, the complainant has not mentioned anything as if he has given money to the present accused petitioner.
Charge sheet filed.
Yes, we are.
Charge sheet has been filed.
No, ma'am.
Then how are you involved? Are you named in the FIR?
Yes.
Huh?
Yes, Your Lordship. I'm the co-accused.
Yes.
There is also a handwritten agreement between the opposite party. The main accused.
Petitioner submit. He has, though he is named in the first information report, no specific overt act is lodged, is leveled against him. He prays for quashing of the impugned proceeding. We have considered the averments in the first information report. In the report, it is alleged one Babul Mondol had dishonestly induced the de facto complainant to part with 17 lakhs on the false promise of giving employment. Giving training and employment. Subsequently, the complainant was handed over appointment letters which were fake. Full stop. The allegations are serious and disclose cognizable offense. Investigation is in progress. In such view of the matter, it may not be prudent to quash the proceedings so far as the petitioner is concerned. In the event charge sheet is filed against the petitioner, upon conclusion of investigation, charge sheet is filed, it shall be open to the petitioner to agitate his grievances in accordance with law. Next.
All right, I'm for the petitioner.
Yes.
Allegation under Foreigner Act and 465, 467 and 468 of the Indian Code. Or FIR laws page 60 page 62 operates part. Or during the inquiry, it will learn that such and such seal came to Guskara about 9 years ago, 31st January 2024. Then if 9 years ago, he prior to that he rented at Guskara tenancy agreement page 23. That is 2013. Then amendment of 2015 notification page 70 passport entry to India amendment rules 2005.
We have considered the amendments in the impugned charge sheet. It appears, it is alleged therein that the petitioners had illegally entered India in 2016.
Exemption of Foreigner Act
2016, and they possessed a Bangladesh. At that time, they possessed a Bangladeshi passport. Subsequently, on the strength of false documents, they have procured an Indian passport in 2023. In light of the aforesaid averments, prima facie ingredients of the alleged offenses of forgery and cheating, as well as under Section 14 of Foreigners Act as disclosed. We do not find any merit in the quashing petition, and the same is dismissed. Next.
I'm for the petitioner, my lord. Petitioner is the accused person under 150 clause -4 petitioner along with 3 persons was accused, my lord. Out of them, 3 persons has been non-charge sheeted. Only charge sheet has been filed against the petitioner under section 341, 323, 354, my lord. My lord, the petitioner got an employment of postal department on compensation ground, my lord. My lord, the trial is continuing since 2000.
Expeditious disposal. What is the stage of the proceeding?
My lord, only out of 9 PW, only 2 witnesses, one witness has been examined.
Petitioner is the sole accused. The case was registered in 2019. He prays for expeditious disposal and is pending till now. He prays for expeditious disposal of the case. Mr. So-and-so, learned counsel, empaneled with the state, is requested to appear. Copy of the petition is served upon him. We have considered the materials on record. We note charge has been framed.
Charge has been framed.
We note that from the order sheet, we note charge was framed in January 2023 and recording of prosecution evidence is in progress. Petitioner contents in the meantime, he has been appointed to public
postal service.
He has been appointed to a public post on compassionate grounds. But his appointment that he has been selected for appointment to a public post on compassionate ground, but due to the pendency of the case, he could not be appointed. In such view, this gives rise to an exceptional situation which requires this court to exercise superintendent's jurisdiction and direct the trial judge to conclude the case at an early date. Accordingly, we direct the trial judge to conduct the trial on a day-to-day basis, subject to the pendency in his file, and conclude the same at an early date, preferably within 6 months from the next date fixed for recording evidence without granting unnecessary process.
Good.
14, my lord, I am appearing on behalf of the petitioner. The
for the opposite party.
Very good.
my lord, the petitioner was the de facto complainant in a case.
Why?
My lord, the petitioner was the de facto complainant in a case under section 465, 468, 471, and other sections of the IPC. It culminated in an FRT at the conclusion of the investigation. The petitioner preferred a Narazi application, my lord, that was allowed by the learned magistrate. I have an
They have gone in revision.
My lord?
Revision petition is pending.
My lord, that revision petition is pending. I am confining my prayer, my lord. The next date my instructions is on 4th of March, my lord. If that revisional application, if your lordship can pass a direction to expedite the hearing of the revisional application.
Petitioner is the de facto complaint. Copy to Manna.
Yes, my lord.
Petitioner is the de facto complainant. Full stop. He submits the police the police conducted perfunctory investigation and submitted final report. He preferred a protest petition which came to be allowed. This has been challenged in CR Criminal Revision number 576 of 2024, and the proceedings have been the order for further investigation has been stayed. He prays for expeditious disposal of the revision petition. Mr. Manna appears for the opposite party. He contends no case, no cognizable offense is disclosed in the facts. He contends that investigation was done in a proper manner and no case for further investigation has been made out. We are of the view the issues canvassed before us required to be agitated before the revisional court in criminal revision number so and so. Accordingly, however, as further investigation has been stalled, the revision proceeding requests to be disposed of at an early date. Hence, we direct the revisional court to dispose of the proceeding on the next date fixed, and if it is unable to do so, to fix another date to dispose of the same as expeditiously as possible without granting unnecessary adjournment.
Can it be by the end of April? Because I gather that the learned lawyer who is
We have said the next date, or if not, on the another date which the revisional court may fix without granting unnecessary adjournment to the parties.
I'm a pleasure.
Next.
I'm going to the petitioner, the husband. The wife filed application under section 125 of the criminal procedure against me. The wife also filed a petition for interim maintenance. That petition has been disposed of, and London Magistrate has been pleased to pass an order directing me to pay 2,500 to the wife and 2,500 to the son. Thereafter, the revision has been filed before the Sessions Court, and the Sessions Court enhanced the order, the 2,500 to 4,000, and to the son, 3,500. Against that, I have come. My humble submission before this court, the learned magistrate has been pleased to pass an order from the date of the order, but the learned judge, it has been passed from the date of filing of the application. Besides this, the son is a major. So my 2 points are there. So kindly consider this, and I pray the limited period for stay. The son is a past engineering degree, and elsewhere his work is still there. The learned judge passed this order.
All right. Petitioner has assailed order dated order dated order dated 19/12/2023, whereby the revisional court enhanced the interim maintenance payable to the opposite party wife and son at the rate of rupees 4,000 per month and 3,000 at the rate of 4,000 per month and 3,000 per month for her son from the date of filing the application. Relationship between the parties are admitted. Full stop. Petitioner is a police officer, and as per the affidavit of assets, declared his gross income at 46,000, gross income at the rate of 46,126. Deduction mandatory, though he has taken his mandatory deductions do not exceed rupees 9,240. In view, though he has taken a loan, comma, his mandatory deductions on account of GPF, etc., do not exceed 9,240 per month. This would make his per month he has per month. He has no other full stop. He has a self-acquired property, immovable property, and no other dependent. In such in this opposite party wife does not have any income of her own. It is argued that the son has attained majority since 2019. Full stop. However, he is also not a earning. However, he does not have any income. Given this situation, direction issued by the learned, given this situation, enhancement of maintenance by the learned magistrate at the rate of 4,000 per month for opposite party wife and 3,500 per month for minor son from the date of application is unexceptionable. Needless to mention, the from date of application is unexceptionable. Needless to mention, the son is entitled to maintenance till he has attained majority. Full stop. With this observation, application dismissed. Next.
Apply for the petition. The washing of a proceedings not under section 379, 427, 506, 448, 34 against blood. The employee of Tata Motor Finance Corporation.
Petitioners are the employees of the finance company, who is the owner of the vehicle.
One petitioner.
Petitioner is who is the owner of the vehicle. The vehicle, the hirer failed to pay installment charges, and the vehicle was taken possession as per the terms of the agreement.
Again, Lord, the police has given to him. The
ingredients, terms of the vehicle. Ingredients of offences, alleged offences are not disclosed. Petitioner has made out an arguable case for quashing, 4 weeks, 6 weeks stay, service. নেক্সট পুরো জানো তো কিভাবে করতে হয়? নেক্সট সেভেন্টিন ও বাগরাম কেস petitioner had instituted a proceeding under section 340 CRPC. Petitioner husband inter alia petitioner opposite party number wife instituted a proceeding under section 12/23 of Protection of Women for Domestic Violence Act. In the said proceeding, she filed affidavit of asset alleging that alleging that she had not made full disclosure in the affidavit of asset and suppressed a bank account in her name. Petitioner husband took out an application for perjury under section 340 CRPC. The jurisdictional magistrate and revisional court dismissed the said application. Petitioner contends that petitioner has challenged the order. I have perused the order passed by the revisional court. I've perused the order passed by the revisional court. The court correctly recorded the stance of the opposite, correctly recorded that the opposite party number one wife had stated that she inadvertently failed to disclose the said bank account. Mere mistake, unintentional mistake on the part of a litigant to disclose a fact would not constitute an act of perjury. I do not find any reason to interfere with the impugned orders. Application dismissed. Next.
Milord, I am for the petitioner. Milord, this petitioner, along with others, they are the joint owner of a property. Milord, they had entered into an agreement with a promoter, Milord, who subsequently, Milord, started construction work. Milord, the promoter had, Milord, exceeds the, Milord, Milord, started working, Milord, beyond the sanction plan. Milord, the petitioner had, and the other co-owners, Milord, they had wrote a letter to stop the proceeding to construction work, and also, Milord, the petitioner had filed a suit for getting injunction for the purpose of, Milord, the construction work. Milord, in the meantime, Milord, the corporation had also, Milord, filed an FIR.
Petitioner contends he is the owner of the premises. He was unaware of the unauthorized construction undertaken in the premises by the developer. He prays for quashing of the impugned FIR. The FIR, in the FIR, it is alleged that illegal construction had been undertaken in the premises. In light of the aforesaid fact, investigation is still in progress. In the event the issue raised by the petitioner with regard to absence of requisite knowledge is a question of fact which cannot be gone into at this stage. In the event the investigation results in filing of a charge sheet against the petitioner, he is entitled to agitate this defense at the appropriate stage of the proceeding. With this observation, application disposed of. Next.
Item 19 minutes become infructuous because after filing of interim order challenge, my lord, final order has already passed. So it became infructuous.
Application has become infructuous as final order of maintenance has been passed. Accordingly, application is dismissed as not pressed.
Diploma.
Next.
20 my lord, I am for the petition. My lord, petitioner, my lord, two maternal uncle was murdered, my lord. Case of 302. My lord, further
Petitioner
investigation
submit
was
that investigation was done in a perfunctory manner. You have prayed for further investigation.
Yes, my lord, that as application has been rejected.
He prayed for further investigation. However, the said
whose name in the
once again it is
stated 164, same name has
Let
been
the
cited as
statement of
witness.
order corrected against those persons. There is nothing.
161 my lord statement they have stated my lord, no name my lord as, but 164 magistrate before the magistrate they have stated the names.
Well,
those names has been cited as witness, charge sheet witnesses. Not my lord, police not interrogated them, not asking them.
Suspicion.
That's too bad.
Out of suspicion. What we do is, in the event any evidence comes against them, magistrate may be entitled to invoke 319 CRPC. They were not FIR name.
Yes.
So 319 is open.
Yes.
Right. Petitioner is the complainant. He contends the investigation was not done in a proper manner. Investigation was not done in a proper manner. Respondent number 2 and though respondent number 2 and 3 are named by witnesses before magistrate, they have not been cited as accused. Hence, he prayed for further investigation, which has been turned down. We have considered the materials on record. We have also
no, my lord, these two respondent name wala charge sheet have been submitted. Here the my lord respondent number 2 and 3 that are my lord charge sheeted. They are
against whom do you want the investigation?
That application I have my lord name 164 my lord statement that their name has been disclosed.
2 and 3 now. Against give the two names.
Names my lord.
Where have you said? Yes. Ashalata and Bhagavati.
Yes, my lord. Those are 164 statement, my lord. Two names has been stated.
So which are those two names? Who are these names?
My lord, application my lord.
The application is kothay gelo?
Last page.
Last page. চার্জশিট দাখিল করিয়াছেন
is 23. Pranab Kumar Das, Gaurhari Mal, and Nirmal Kumar Mondol. Those three names.
Where? Read out.
That is page 23, my lord, charge sheet. Witnesses, my lord. 13, 14,
witnesses. So how will we know?
Those names are stated in the 164.
Oh, that is not clear. Even in your application, it is. Ki bollam jano? No, those some persons were named by the witnesses as accused. They have not been cited as charges. They prayed for further investigation, which came to be turned down. We have considered the materials on record, including the impugned order. In the impugned order, learned magistrate rightly observed that the statements of the witnesses under 164 CRPC merely express suspicion against some persons. Their earlier statement before police do not implicate them, full stop. In this backdrop, learned magistrate rightly declined prayer for further investigation. I clarify, in the event evidence comes on record, credible evidence comes on record against other persons apart from the accused charge sheeted, it shall be open to the trial court to invoke its powers under 319 CRPC and array them as accused in accordance with law. With this observation, petition disposed. Next.
I am for the petitioner, my lord. My lord, by virtue of the High Court order, FIR was registered under offense under section.
What do you want?
My lord, charge sheet submitted excluding the schedule type.
All right.
Yes, my lord.
Petitioner submits that in spite direction given by this court to register FIR under the provisions of Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, the said offences have not been added to the charge sheet. It is open to the petitioner to agitate this grievance before the jurisdictional magistrate, and in the event the magistrate is of the view that offences under the aforesaid provisions, offences under the special act are disclosed, to transfer the case to the special court for trial in accordance with law. With this observation, application disposed. Next.
May please the my lord, I am for the opposite. 406 120p, but parties have settled their disputes amicably.
Where is the joint?
That's there, my lord. 10-1.
Petitioners have amicably resolved their matrimonial dispute, giving rise to the impugned prosecution. A joint petition, a joint affidavit disclosing this fact is placed on record, being granted so and so. State lawyer, Miss So-and-so, learned advocate for the state, is requested to appear in the matter. Copy of the petition and grant so-and-so is served upon her in view of the aforesaid provisions and in light of law declared in B.S. Joshi.
You quoted Gyan Singh, madam.
Gyan Singh bigger, B.S. Joshi. Gyan Singh so-and-so, we are inclined to quash the proceed. Please give the citation. Next. 23. Anta Sen. Petitioner is the is a relation of one Chittaranjan Sen, since deceased. It is contended she and others, and she had taken care. It is contended during his illness, she took care of the. She took care of Chittaranjan and Chittaranjan in regard to took care of Chittaranjan. Medical expenses were met by drawing money from the joint account. From the joint account. Subsequently, Chittaranjan died, and his son has instituted the impugned false case. Ingredients of the offense of cheating and criminal breach. Uh, Ingredients of offense and of cheating and criminal breach of trust are not made out. Under such circumstance, petition has made out an arguable case in appeal. There shall be stay of proceedings, so and so, so and so service. Next.
24.
24. Petitioner contends that Petitioner is the complainant. He contends that the charge sheet was filed. She complains pursuant to a perfunctory investigation, charge sheet was filed in a manner to ensure the exoneration of the opposite party. Accordingly, she prays for further investigation. Copy of the petition be served upon opposite party number 1 through public prosecutor, 2 through registered speed post. There shall be stay of proceedings for 6 weeks. Next.
I beg to appear on behalf of the petitioner, Your Lordship. This is my application praying for setting aside of the order of stay granted on the issuance of warrant of arrest, Your Lordship. Petitioner is the de facto complainant. Petitioner lodged a case pursuant to which the opposite party number 225 preferred 438 application before the Sessions Court, Your Lordship. A date was given for production of the case diary and a report was called for. Thereafter, Your Lordship, on the next day, the opposite party surrendered before the magistrate, completely suppressing the fact the 438 application was pending and they obtained interim bail, Your Lordship. Thereafter, the petitioner preferred a cancellation application and the bail was cancelled.
No scope for interference. 438 application pendency does not preempt him from appearing and praying for regular bail. Even notice we are not going to stay. Petitioner submit that opposite party had falsely had suppressed the fact that an application for PRS bail was pending and had obtained interim bail. The interim bail was cancelled and warrant was issued. Revisional court has illegally set aside the warrant. Copy of the application be served upon opposite party number 1 through public prosecutor, 2 through registered speed post. Matter will appear 4 weeks hence.
I'm grateful, Your Lordship.
Next.
I am for the petitioner. My Lord, in this application, I am challenging the order of the Sessions Court, whereby the Sessions Court, by order dated, my Lord, 21st of June 2024, had rejected my revisional application for squashing of the complaint under 138.
Why should it be quashed?
My Lord, kindly comes to the complaint once. Page number 39, my Lord. If your Lordship kindly comes to the next page, page number 40. If your Lordship will see the third paragraph. The endorsement by which the check was returned. Kindly see the endorsement, my Lord. Referred to draw with the note that this check deposited by you has been dishonored by the Allahabad Bank with the reason executed arrangement. Executed arrangement.
Exceeds arrangement.
Kindly see, my Lord. And my Lord, there are few other points also, my Lord.
Tell us what few other point? No point.
Well, this
petitioner is aggrieved by the rejection, by the dismissal of the prayer for quashing of the proceeding under section 138 of NI Act. I have perused the petition of complaint. In the complaint, it is alleged that the check issued by the petitioner accused upon presentation was returned unpaid with the endorsement exceeds arrangement. The said expression means that the amount in the account was not sufficient to honor the check. Notice of dishonor was issued. Ingredients of the offense are
Kindly
disclosed.
see, my lord.
It is open to the petitioner to agitate his grievance defense during trial if so advised. Next.
My lord, I am appearing for the petitioner. My lord, I am not placing this application.
Not placed, dismissed. Next.
Lordship, item number 28 and 29, I am appearing for the petitioner. Lordship, the proceeding has already been dropped before the learned.
Dropped. 28, 29, not pressed.
Deeply obliged, Lordship.
30. Supreme infrastructure.
And for the petition.
With Chalo, এটা last.
Complaint case 406, 418, 420. My lord, there are 4 petitioners. My lord, in respect of other accused persons, my lord.
When Oyan Bhattacharya compete. So many documents, Mr. Saurabh Chatterjee, a revision, a quashing court should not see. Trial court should see. All right, go back to that.
Only 181, my lord.
No, nothing.
181.
There
Only
are
180.
too many documents annexed. 181.
Lord, in respect of others, my lord, there is an interim order passed by this honorable court, my lord. It has been extended from time to time. My lord, complaint case, my lord.
What is the others? Where is 181?
181, my lord. 181. Annexure P9, my lord.
Match names. Petitioner contends that proceedings have been stayed where co-accused. Accordingly, he prays for quashing of the proceeding on similar ground. Same case.
My lord, same case, my lord.
Has been a co-accused in CRR. In light of the aforesaid submission, we direct that the matter be heard along with CRR so and so. Copy of the petition be served upon so and so. There shall be stay of proceedings for 6 weeks or until further.
I'm deep.
Other matters tomorrow.
Obliged.